Welcome back to the Joe Miller Show, KOAN Hot Talk, 1080 AM, 95.1 FM. We have with us Karen Bennett, author of Redefining Waters of the United States. Is the EPA undermining cooperative federalism? We posted that at restoringliberty.com, joemiller.us today. For some background, go to that article. She is a practicing attorney. She's been working for over 15 years in the D.C. area, addressing issues such as EPA overreach. And Karen, appreciate to have you on because there's some rulemaking going on that could have some dramatically adverse impacts to Alaska, right?
That's right. Thank you, Joe, for having me tonight.
Well, I appreciate you agreeing to be on the show. I just wanted, by way of background, I didn't mention this during the break, but I helped sue the Corps up in Fairbanks. They were asserting jurisdiction over permafrost land, not even standing water. Vegetation was basically the way that they made their determination. And it's just amazing the costs that folk, of course, all over the country, but particularly here in Alaska, undertake because of what the EPA has done, which is clearly beyond what was intended. Could you express to our audience basically what this new rule is and why it poses a risk to property owners?
So this rule is about redefining waters of the United States, and that's a legal term that's fundamental to establishing the reach of federal authority under the Clean Water Act. And in states like Alaska, where over 50% of the state, as you said, permafrost, most of the state is considered wetlands, the rule would have a profound effect. You also mentioned, Joe, the timing of our discussion tonight. We think this rule could be final by Friday of this week. And that's one of the things we looked at in what prompted our investigation of the rulemaking docket, the comments that are filed in the public comment phase of this rulemaking. It appeared to us by talking with states and local governments that EPA was in a big rush to finalize this rule. It will, as I said, have a profound effect on not only states that under the Clean Water Act, Congress intended states to have primary jurisdiction and primary authority over making decisions about how their lands and waters would be used, but also on private citizens who now may be faced with getting a permit from the federal government, which comes at great cost and time and effort, but also through some mitigation provisions that would be required by this rule. You would actually have to pay the federal government through mitigation to actually use your own property. So these are things that we think warrant a great deal of attention. The states have spoken out, and our research shows that 34 states oppose this rule and have filed comments with EPA asking them to withdraw the rule and undertake a robust consultation with the states and with obviously other stakeholders as well, and more thoughtfully proceed and not rush to finalize something that would have such a profound economic effect on the country and the nation.
Can you give us kind of an idea of the practical impact of this rule change if it goes through? Do you have numbers as far as acres that are currently under jurisdiction compared to those that will be if this goes through?
So, for example, ditches. When you think about roadside ditches, we all know what that looks like. Ditches on a farm field, on agricultural land, people are pretty familiar with that as well. Ditches would be per se jurisdictional under this rule as tributaries unless they meet very limited exceptions. And then the burden shifts to the landowner to show that they're not included as jurisdictional waters. So that's a fundamental shift in the way that we've been operating under the Clean Water Act historically. That's one example. So when you think further along those lines, entire water systems within states that are used to, move water around for irrigation or drinking water, or I've worked a lot in the mining sector. Industrial and mining sites are required to manage stormwater and on those sites. And those systems, we think, will be captured by this rule. Ditches on farm fields, I mentioned, and along roadsides. We say the rule, we feel those would all be swept into jurisdiction.
And that's terrifying, because then, I mean, if you fill a ditch, if you have fertilizer or herbicide or something like that washes into the ditch, I mean, I guess technically you then have to have some sort of a permit, right, from the EPA to do that?
You have to have a permit, and when you talk about costs of this rule, one of the big deficiencies or oversights that I see is when you get a permit for any impact to those waters, anything you're going to do in or around those waters on your own property or the state on its properties would require a permit now from the federal government. That's going to open that project up to public comment and review, and people who want to oppose your project can come out and say so. So that costs a lot of money and takes a lot of time. Notwithstanding that is the mitigation requirements. So for every impact, you would be required to negotiate some amount of mitigation for those impacts in order to get the permit. The cost of that, you can opt to do that mitigation yourself, or you can go to a mitigation bank and purchase those credits. The amount of mitigation you'll be required to bring to the table is a negotiation, really, and it's determined by the agency. And then that's just the half of it. Once you decide how much mitigation, then in our experience, the agency will likely ask you for a 50 to 100-foot buffer on that mitigation project. They'll also they may ask you for a bond to assure that work gets done. They may ask you even to transfer that property, that mitigation property, the surface ownership of that, to a third party that would be a steward of that land with a conservation easement for perpetuity. And even further, they may ask you to relinquish all mineral rights that would be associated with that property. So,
hey, Karen, we got to go to break here in just a minute. But I mean, what you're talking about is just devastating as far as the property cost. I mean, it's a taking effectively. Where's Congress? You would think they'd be engaged.
They are. We can talk about it.
All right, great. We'll talk about that coming up. Again, what Ms. Bennett has suggested here, at least for agricultural lands, I mean, I couldn't imagine any farmer being able to take this without having severe financial consequence. Permitting if you have a crop and you apply a herbicide or fertilizer, just absolutely crazy. EPA out of control. Stay with us. More after this break. Welcome back to the Joe Miller Show, KOAN Hot Talk, 1080 AM, 95.1 FM. We have with us Karen Bennett. She's an attorney. She's been working for over 15 years against the EPA, other groups she practices in Washington, D.C. Been following this new rulemaking by the EPA could have devastating consequences to the United States, to landowners throughout the United States, where the EPA is considering extending its jurisdiction to artificial waterways such as ditches. Already been some of that, but this would be by rule expanding with the breadth of jurisdiction by millions of acres and having significant adverse impact on miners. Of course, agricultural users have to go to the EPA for permits and do other things to basically buy back their property. Karen, you've been in this fight for a while. Again, you suggested that maybe this rule could get published on Friday. What is the Congress doing to stop this train wreck?
So the Congress is doing, there's legislation pending. There's legislation passed on the House side and pending on the Senate side. But, of course, we have every reason to believe that that legislation if passed, would be vetoed by the president. This is a very high priority of the administration, and I guess that's in part why we published our article that really responded to EPA's assertions that there's widespread support for the rule and that EPA had done significant outreach and consultation with states. What we were hearing and what we tried to stay true to in our accounting of the rulemaking docket, using really the state's words in our article to respond to that.
And that article, Karen, just so our listeners can go there while you're talking about it, redefining waters of the United States as EPA undermining cooperative federalism. That's up at restoringliberty.com, joemiller.us if you want to follow along. You assert in this article effectively that the EPA misrepresented not just the support for the rule change from the states, but even their outreach to the states, right?
There's been conversations that span administrations on this issue, on this topic. There's been litigation for decades. So EPA has essentially considered the consultation with states and the discussions with states over the history of this issue to constitute consultation on this rule. That's what they would say. We think that's insufficient, in the states, in their own words, as published in our article, agree or are stating that that's insufficient. EPA did not discuss with the states in sufficient detail what they intended to propose. And, public comment and consultation with states, the goal of that is that you would bring in meaningful information that the states, as co-regulators under the Clean Water Act, would be able to share valuable information with EPA about how waters within those states are regulated currently and, what more needs to be done, if anything. It appears as though EPA sidestepped or stepped over that step or disregarded that valuable process of rounding up those kinds of comments and having those kinds of valuable conversations, so that the end product, the final rule, would be a better rule, and a rule that would be of more protective of water, but at the same time respectful of the state's role under the statute.
Now, this did not just engender the opposition of 34 states, but also the proposed rule has generated an enormous amount of public commentary, right?
It has, and in fact, the New York Times today published an article that looks at that. It appears as though the administration itself used its own Twitter accounts and to generate support for the rule, and there's some people that are looking at that and taking issue with that. So it appears as though there's widespread comment, but if you actually boil down, how many of those comments are actually substantive comments versus how many of those comments are postcard comments that say, I support clean water, with a picture of a child drinking water. Right. That's where that debate is going.
Now, if this rule actually gets enacted, again, there's a 60-day period after the publication on Friday, assuming it comes out then. The fact of it is EPA is going to have to make an enormous increase in staffing, and that's only going to happen if Congress decides to appropriate the money to the EPA to do so. Are we talking about thousands of more EPA workers, Corps of Engineer workers? Are we talking about tens of millions of more dollars for the EPA? Do you have a monetary or number amount that we could pin to this thing?
We do not have a number like that. The Army Corps of Engineers is on the front line of actually implementing the 404 part of this. But this rule applies to the entire Clean Water Act, all of the programs underneath it. So a substantial amount of this, the impact of this, is an unfunded mandate on states. Most states have, assumed jurisdiction, primary permitting authority under the Clean Water Act for a number of programs. So the states are very concerned that they don't have an adequate consideration has not been given to what it will take for states to actually implement what will be imposed here. So, we don't think that the economic analysis and the costs that will be imposed have been adequately considered. And I think that's an important point that you raised.
We're hitting into this segment. What can people do? Is there anything they can do now except for put pressure on their elected representatives?
So I think you can put pressure on EPA. I think people should be calling the administrator, Administrator McCarthy, calling the White House. I think that's where this decision lies about when this rule will actually be published as final, and that hasn't happened yet. So there is opportunity to voice your concerns.
All right, Karen Bennett, thank you for keeping up the fight against the EPA, letting us know what's going on with this new proposed rule. Appreciate your insights, and especially the article that we have up at restoringliberty.com. Thanks again for being on the show.
Thank you.
Stay with us. The Joe Miller Show, back with you after these messages.